Si quieres, una vez que entre la gente, vamos a decir que vamos a grabar.
Pleasure to meet everyone. I'm honored to be doing this with Juan Luis. Buenos dias. But my name is Evan Nadell. I'm a litigation partner at the law firm of Kilpatrick, Townsend, and Stockton. I'm based in our New York and San Francisco offices. And I'm the co-chair of our class action practice group at Kilpatrick. I'm admitted to practice in New York, California, and Florida. And I'm going to be speaking mostly about New York law today. I just wanted to sort of introduce the topic first. Overall, I think everyone should be aware business transactions involve difficult negotiations over complicated terms, like stock ratios and valuations and accounting methodologies and earn-out thresholds and the like. The parties usually give little thought to the section at the end of their stock purchase agreement or asset purchase agreement that's often called miscellaneous. And that section is the one that has a lot of provisions that can be really important, like a choice of law and choice of forum provision, like the ones we're going to talk about today. If you're counting on the law that's chosen in the contract to apply whenever a dispute arises later, then it could change the outcome for your client if the court actually says, no, I will not enforce the choice of law clause or the choice of forum clause. And even if the court says yes and does enforce it, it could turn into a long, expensive procedural fight before you even get to that decision from the court. And so you may win, but still have an angry client at the end of it because you had to spend a lot of time and money to prove that that provision should be enforced. So being careful up front about some key issues can help avoid those problems later, so that when there is a dispute, you can be confident that you will get to litigate the merits of that dispute in the court that you choose with the law that you choose. So that's part of what we're trying to do here, is help make sure that that's what happens. I'm just going to ask if anyone's, if anyone can just mute themselves who aren't speaking to avoid some background noise, that would be helpful. Okay, so I'm going to talk mainly about New York law because that's a popular jurisdiction for commercial disputes. It's one of the states where I'm admitted. And so I'm going to start with choice of law clauses under New York law and their enforceability. So normally, if the parties and their transaction have no relationship to New York, then a New York court is not likely to apply New York law. So for example, a person in California buys a product from a company in the state of Maine and gets injured using that product in California, and the California buyer decides to sue in New York, a New York court is not going to apply New York law. That has nothing to do with New York. Okay, so that's a classic example without a contract provision. So what if the parties agree to use New York by adding a New York choice of law clause? So in that same example, what if the seller of the product in Maine on its website has terms and conditions with a New York choice of law clause? So what's the result going to be then? Well, it could be the same thing. The New York court could still say, no, we don't apply New York law because when you have a contract clause that says you apply New York law, period, that includes the entire law of the state of New York, which includes New York's choice of law rules. Those choice of law rules under New York law require a court to do an analysis of all the parties' contacts with the state of New York to determine what's called the center of gravity, or which jurisdiction has the most significant relationship to the transaction or events. And so some of the traditional factors that courts in New York will use to make that determination are things like the place of the contract's negotiation, the place of the contract's performance, the location of the subject matter of the contract, the domicile, residence, nationality, principal place of business, the place of incorporation of the parties. All of those things go into that analysis that the court does as part of its own choice of law test. And that, as you can imagine, can sometimes be messy and expensive. The parties have to submit evidence to the court saying, here's all the things that happened in New York, or here's, if you're on the other side of it, here are the things that didn't and why it should be somewhere else. And so the judge is then going to look at all that evidence and decide. And as you can imagine, that's also a very unpredictable process. With all those different factors, it's not exactly a mathematical formula how the judge will rule on which law it considers to be the most significant or the center of gravity. And so there's not a clear outcome in most cases. And if we're talking about business transactions, you definitely want certainty, you want a clear outcome. So that's why there's a way to draft around that problem. And incidentally, one of the things that came up in the old days before people had good choice of law provisions is you could have what's called the renvoi problem, which is a French word. But essentially that whole process I just described, the New York court could look at that example I gave and say, oh, I think Maine law should apply to this. That's where the product was made and that's where it was sent from. And the law of Maine could include Maine's choice of law rules, which could do that whole analysis and determine that the law of New York applies. So now you have this circular problem where one state points to the second and the second points back to the first. Anyway, good drafting can avoid all of those issues. So the way to avoid that is having clever lawyers put in a New York choice of law clause that says it's governed by really the substantive law of New York, regardless of New York's choice of law rules. So you're asking the court to skip that first step and go right to the relevant law of New York without that New York choice of law test. So new example, you have X Corp based in the state of Texas that buys a specialized machine from Y Corporation in the state of Ohio for $200,000, but the machine doesn't work. And the parties put a New York choice of law provision in their contract with the magic language that says, we're applying New York's law, but not the New York choice of law test, just the New York substantive law. So in this example, the court's going to apply New York law, right? Wrong. The court in New York is not going to let the parties agree to apply its law where there is still no relationship between either party or the transaction to the state of New York. In this example, you have Texas and Ohio companies with a machine that never goes through the state of New York. And so a New York court's going to say, why should our law apply to this transaction? It's not involving the state of New York, unless the transaction is for $250,000 or more. Then New York will allow it and recognize that parties might like to use the well-developed commercial body of law that exists in New York and can reliably have New York law applied, even when none of the parties has anything to do with the state of New York and the transaction has no connection to New York whatsoever. So one last example on this to demonstrate the point. Company A in California buys Company B in Florida for $10 million. The stock purchase agreement contains a choice of law clause with the magic language saying that the substantive law of New York governs any contract dispute that arises. But nothing about this transaction touches New York, and neither company has any offices or employees or does any business in New York. Is that New York choice of law clause enforceable? Yes, because it's more than the $250,000 threshold. In this case, it was a $10 million deal. They got the magic language. So in this situation, it will be enforceable. So you can see the requirements are a clear written contract provision, selecting New York law without regard to the choice of law rules of New York, and a transaction value of $250,000 or more. So that's the New York choice of law analysis. Now I'm going to turn to the New York choice of forum law. Now, you might think, why am I doing this after choice of law? Don't you normally pick the forum first, where you filed the lawsuit, and then determine the applicable law? And the answer to that is yes, but New York law makes the enforceability of a choice of forum provision turn in part on having an enforceable New York choice of law clause in the contract. So that's why I talked about choice of law first. Once you've got that in your contract, your maximum chance of having that choice of law provision enforced, which is the most important part, is to also include a New York choice of forum provision. So you're not just having the laws of New York, but you're also in the courts within New York. If your agreement has an enforceable New York choice of law provision, then you just also need to say, quote, any dispute arising out of or relating to this contract will be filed in New York. Is that good enough? Not that simple. There's really 3 requirements to making sure the choice of forum clause is going to be enforced. Number 1, as I just mentioned, you want to have the enforceable choice of law clause under New York law. We just discussed that. Number 2, the transaction now must be in an aggregate amount covering at least $1 million. So not just $250,000, but at least $1 million. And the third requirement, the choice of forum provision has to include an agreement by the parties to submit to the personal jurisdiction in the courts of New York. So to make that clear, here's an example. A corporation in Argentina merges with a corporation in Brazil in a $50 million transaction that includes a New York choice of law provision and a provision that any lawsuit arising out of or relating to that transaction will be filed in the New York courts, but the transaction otherwise has nothing to do with New York. Now, there's a post-closing dispute over an earn-out provision in that contract, which is very common, and the Brazilian corporation files a lawsuit in New York state court. Are they good? Is that going to work? Not so fast. It doesn't work unless that choice of forum provision also says that both parties consent to personal jurisdiction in the courts of New York. Otherwise, in that situation, that example, the defendant, which is the corporation in Argentina, can dismiss the case for lack of jurisdiction. They can say, I've never set foot in New York. I have nothing to do with New York, even though we have a contract that consented to apply the law of New York and consented to the courts of New York hearing the fight. That doesn't mean I consented to being subject to the jurisdiction of the courts of New York. So the choice of forum provision needs to also include that language about personal jurisdiction. And here's another important point to consider with respect to the choice of forum, not just under New York law, but really any state within the United States. And that's the difference between state and federal courts. Some people might be familiar with this, but if you're not from the US or if you're not used to US litigation, this is not always clear to people. But the US federal courts are courts of limited jurisdiction. They cannot and will not take every case. And if there's not a violation of a US federal law, then there must be something called diversity of citizenship. That means citizens from different states or from one state in a different country that are in that dispute. So, for example, a citizen in Mexico cannot sue a citizen of Canada in federal court in New York, even if the two of them came to New York and all of the relevant events happened there. This is true of any federal court in the US, not just a federal court in New York, but a federal court in Kansas or Texas or anywhere else. And in that situation, there's not diversity, even though they come from different countries, because neither one is from a state in the US. So similarly, a corporation formed under the laws of Mexico and based in Belize cannot sue a corporation formed under French law and based in Madrid in federal court in the US. They're plaintiff and defendant from two different countries. So even if they have a fully enforceable contract with a New York choice of law provision and choice of forum provision, the federal court is going to say, that's great, good for you, you agreed on this, but that doesn't give me a federal judge jurisdiction over the case because I don't have diversity jurisdiction. I might be different if you're talking about an LLC that has some members in a US state, or one of the corporations is formed under Delaware law, but that gets a little more complicated. But so in both of the examples above, federal court would not have jurisdiction, but a state court in New York would have jurisdiction and would accept that case with the enforceable choice of law provision and choice of law provision in the contract. So what do you do with that if you're in a position of drafting the contract? Well, the point is, do not draft a contract that has a choice of forum provision that says the exclusive jurisdiction of any dispute between these parties will be in the United States District Court for the Southern District of New York or any other federal court. Because in the end, that court might decide that it does not have jurisdiction, and the judge will dismiss the case even if both parties want to be there. And now you've said that that's the exclusive jurisdiction, and that court says, I don't care, I'm not hearing the case. So it's as if you have no choice of forum provision at all. And you're back to a world of uncertainty about which forum will hear the case. So a good choice of forum provision should use the magic words exclusive jurisdiction. If you just say the parties may bring the lawsuit, that's more optional, and that means other courts might also be able to hear it. But if you say exclusive jurisdiction, that's good. But exclusive jurisdiction in this example, you would say in the state or federal courts of New York. That way, if there's a preference for the federal courts, you could start there. But if the judge decides in the end, I don't have jurisdiction over this case, you can't be in my court, at least you still go to the state courts of New York. So you get to be in the courts of the state of New York, where your New York choice of law provision is likely to be enforced. And then you can have, again, that certainty about the substantive law that's going to decide the dispute between the parties, which is the whole purpose here, again, is to get through those issues as quickly as possible so that if there is a dispute, you and your clients don't spend a lot of time and money fighting about these what are often called threshold procedural issues, and instead can get right into the merits of the fight. The earn-out provision says if these earnings thresholds are met, then the payment of X should be made, and you go right to those issues with a judge instead of spending a long time on these other ones. Before I turn it over to Juan Luis, I'm just going to speak briefly about California law. I mentioned I'm also admitted in California, and I love the state of California. It's a terrific state, but I have to say, for companies, it is a very challenging environment to be litigating in the courts of California, particularly in the state courts. So while California has policies that generally enforce parties' choice of forum clauses and choice of law clauses, the reality is California courts are often hostile to contracts that select a law other than California, particularly when anyone from the state of California is involved. So for example, there's a public policy exception that California courts apply to enforcing choice of law clauses. If a different state's law is selected, but a court finds in California that it would violate an important interest or public policy of the state of California, then it will not enforce that law. So this is an example from a case that I had. You have an investor who's based in California, who was 65 years old or more, signs a private placement contract with to invest in a company based in Massachusetts, agrees that Massachusetts law governs the contract and will sue in the state courts of Massachusetts. The investment loses money, and he files a case in California and alleges financial elder abuse. In California, the court is likely to reject the Massachusetts choice of law and choice of forum clauses, because it will say that the court in California has a strong public policy in protecting elders, senior citizens in the state of California from financial abuse, and Massachusetts might not have the same level of protection for those people under its law, and therefore it needs to protect the plaintiff and allow the plaintiff to disregard the freely chosen contract provisions that say Massachusetts law and Massachusetts forum, and instead the case gets heard in California under California law. That's upsetting the expectations of the parties and creates a lot of unpredictability for companies. Another example is California courts have a very strong policy against any contract that contains a waiver of the right to a jury trial. There's another strong public policy in California that frowns on those kinds of provisions. If you have that in your contract and you choose any forum with a jury waiver, that provision is going to be unenforceable. And if you've got, so for example, a New York choice of law, choice of forum provision with a jury waiver, and someone sues you in California, the court can refuse to enforce those provisions because it doesn't like that. Third example, if you have employees with employment contracts with employees who live in California, there's a statute that says you cannot force them to accept the law of another state that governs their employment relationship. So how do you avoid being stuck in California courts if you're contracting with someone who's a company or an investor or an executive or someone in the state of California? The best way to do that is to not be in the courts at all and have an arbitration provision. Now, some people love arbitration, some people hate arbitration, but an agreement to arbitrate has a much better chance of being enforced in California than a choice of law or forum clause from another state. And that's because, in large part, there's a very well-developed body of federal law in the US that is governed by United States Supreme Court precedents about the enforceability of arbitration provisions. And those, even though there is no right to a jury in an arbitration because it's a private dispute with a neutral, so it might offend California's jury waiver policy. Those are still considered to be enforceable contracts if it's an arbitration provision, and that's your safest way if there's a risk that you're going to be sued in California, to avoid being stuck in the courts of California. One other option is the state of Delaware has something called a chancery court. That's a specialized court of equity that doesn't have juries because equity courts are only judge decisions. But you can't always count on being allowed into the Delaware Chancery Court. So the arbitration provision is sort of a safer way to protect yourselves from having a California court disregard the choice of law and choice of forum provisions that you negotiated in your contract. So I'm going to stop there on the New York and California front and turn it over to Juan Luis to talk about Mexican law.
Thank you very much, Evan. Well, everyone, thank you for joining us. I am Juan Luis Blanco. I'm a partner at Muga Burgos and Peñalosa, based here in Mexico City. And I do a lot of litigation, and I really, really enjoy talking about this subject. As already Evan introduced this interesting subject to us, our first recommendation will always be to have a really good drafted clause with choice of law and choice of forum that include both elements. The elements that Evan already pointed out from a US point of view, and also those elements from the Mexican point of view that actually, and I'm going to say it right now up front, are really similar, no? And that will help us to prevent and to have easy access to the courts, whether the parties decided to stay here in Mexico or whether parties agree to go to the United States. Also, it is important to mention that in the case that such clause is or not valid, we also have as a general thing in Mexico, we are very, very formalistic. I bet a lot of you guys know already about it. In the absence of an agreement clause or a clause contained in the agreement, then we're going to turn to the law. And when we turn to the law, normally we use these connecting points that Evan also talked about, right? We have to look for the address of the parties, where is the execution of the purpose of the agreement happening, and or where are the assets located. So saying that, our first recommendation would be have clever lawyers, as Evan said, drafting this clause in which, and as a normal practice here in Mexico, all my fellow colleagues will know, we normally include in one clause this choice of law and choice of forum provisions. Regarding Mexico law and talking about those similarities at the beginning, I would like to say that it is always important that both parties agree on the substantive right or substantive law that is going to be applicable, no? And also having an express waiver of that jurisdiction that will be granted by law. So in Mexico, what we would normally see is that the parties agree that the applicable law, the substantive law, would be the laws in Mexico City, right? But then they also will have to have this waiver. And this waiver is now, as you can see, we could have maybe some problems with courts in California, as Evan said, right? But in order to have a really good clause in Mexico, we do have to insert and to put that express submission to waive your rights in order to focus on what is going to be the applicable law. And also, as a general practice, what we do, we also have to appoint those competent courts that are going to resolve our controversy. And in this case, also, as in the United States, we have federal and local courts. These federal and local courts also have specific jurisdictions that are and will be subject of my explanation in a couple of minutes, but that as general rule, it would also be recommended, as also Evan said, to use the and or language so that you will be able to go to a federal court in those matters that have a concurrent or simultaneous jurisdiction, such as commercial law, and or then determine which court will be the one that you are going to pick. No, of course, it is also very important that this court appointed, obviously, has to do at least or is located in the address of one of the involved parties, that this court is located where the execution of the obligations contained in the agreement happen, and also that and or, let me put all these magical words, and or the place of location of the assets. No, bearing that in mind, no, it will be really easy for us, no, just to consider these magic words, and then we will be finishing this conversation or webinar right now. Unfortunately, then again, it's not always that easy. No, it is important to consider from a Mexican point of view, talking about these very formalistic procedures, the details and specific things that has to be taken into consideration so that this clause would be effective and will allow us to, as Evan said, go directly to court, file a claim, and then although the defendant might argue an incompetence provision, you will be, so to say, secure that at least you won't be spending a lot of time trying to get your claim admitted by a court here in Mexico City. So the first thing or the first point that I would like to bring into this conversation is the Mexican Constitution. If you look at the Mexican Constitution establishes what is going to be, or what is the jurisdiction of federal courts, no? Because also, as it happens in the US, these federal courts have a limited or have a really specific jurisdiction. Not all the claims are going to be admitted by the federal courts. And even, this is as part of our practice, when a federal court has jurisdiction, normally these courts are tending to dismiss the claim, right? The federal courts here in Mexico City are one of the three branches of power. They, as many of you know, they do amparo claims, right? This is a specific and extraordinary constitutional procedure in which these federal courts are resolving and protecting human rights. So when a federal district judge receives commerce litigation, I don't know, maybe shareholders are having a dispute, although they are supposed to accept and to give a course to that claim, normally they would just prefer to dismiss the claim, no? And then we're starting with the left foot. Why do the federal courts do that? Because this is a concurrent jurisdiction, no? The federal courts would say, hey, I dismiss the claim on any grounds or without any grounds. You know what? You better go and fight your, so to say, your claim in the local courts. So from this point of view, no, starting with the Mexican Constitution, we can understand that in civil or commercial claims, when is going to be a federal court wanting to stay with the case? No, first thing is there an application of a federal law or an international treaty? Is one of the parties part of the federal authorities? If your answers were yes to those two questions, then normally, no, or in accordance to the law, your claim will be accepted by the federal courts here in Mexico, right? But if, for example, your claim is only between private parties, although you're talking about a commercial claim in which there are concurrent jurisdiction, you might have a little bit of trouble to get your claim accepted. And this, from my point of view, is actually, or has actually something to do only with the workload of the courts, and that the courts here in Mexico are not very interested in having to resolve a private commercial dispute when they are all the time spending resolving these amparo claims that I was talking about. But notwithstanding the above, if in the magic words that are set in our jurisdiction and applicable law forum, we decided to include the competent courts will be the federal and or local courts in Mexico City, then you can determine where you want to file your claim. So once again, starting from the Constitution, we already see to which forum are we going to go. Now, saying that, and for the purpose of this short webinar, I would like for you to remember that if you're willing to go to a federal court, one of the parties should be part of the federal administration, and or you are going to try to have an application of a federal law. No, that would be like the general rule. Unfortunately, and as it always happens in Mexico, we have exemptions to that. For example, let me put the federal copyright law in place, right? When you see the federal copyright, you see that it expressively says that you can file your claim in the federal courts and or in the local courts. So once again, I have the choice of which court I'm going to pick. If I go to a federal court, the federal court is and should accept the claim without further ado, and then wait for or summon the parties to the claim, right? Notwithstanding the above, from our experience or expertise, we have seen that those federal courts are tending to dismiss those claims, right? So what you have to do is to have a specific part of your claim in which you can support the acceptance of your claim. And this will be very important for Mexican law because you won't have to appeal that first dismissal of the claim rather than having an easy admission, no? That normally those fast track admissions would happen in the local courts that know about this concurrent jurisdiction and would just accept the claims. Okay, but after explaining this, now we are going to have the problem with the applicable law, right? When you talk about applicable law in Mexico, you normally have to go to the Federal Civil Code, in which you will find the specific rules that apply to these circumstances. As I say, it would be great to have a clause in your contract, but in case that you forget to have clause in your contract in case that, for example, this business is having different execution places between Mexico City and or in the United States, then it is very important to mention that Mexico, and first of all, does accept the application of foreign law, right? For us here in Mexico, if the parties agree to apply foreign law, they are capable of doing so, and the Mexican courts will be able to resolve in accordance to that law. For that, we have specific rules that I will say in a minute. But first, and bearing in mind the intention of our Congress, it is important to mention that, for example, Mexican law, it's going to apply to all the citizens and foreign cities and foreign people that are in between our territory, right? So when you see Article 12 and 13 and 14 of the Federal Civil Code, you say, okay, first of all, Mexico is going to govern all the things that happen in between their territory. Perfect. Nonetheless, if the parties are to agree that the applicable law is a foreign law, Mexican courts will also apply that. That is great. No, that is pretty simple. But then also we have these 5 rules in which we're going to foresee which acts, and depending on the subject of the agreement, is going to stay in a federal or in a local court. No, so for example, all the things that has to do with the status and capacity of natural persons are normally governed or are governed by the law of the residents, right? So then the federal code is sending us to the local law directly. So something that has to do, for example, with marriage. Oh, where do the parties live? Mexico City. We're going to apply that specific law. What happens to real estate related assets and real estate related rights and assets? Also, the federal code would send us to the local law immediately. So that's even if, for example, the owner of this real estate or of this house is a foreign people. That's why here in Mexico we always see, that when a foreign person comes to do a long-term lease or a short-term lease of an apartment as to stay here or to do home office from here in Mexico, all those regulations are going to be governed by the local law, right? As I mentioned before, if a party of the agreement and or if there is going to be an execution of a federal law, then the civil code would say, hey, I'm going to stay with the applicable law in federal matters, right? So, for example, if you're going to execute a lease agreement also with a federal entity, normally, or not normally, the specific law that is going to be applied is going to be federal. So depending, and this also is really related to the choice of forum that I already explained. So normally, depending on the party, the subject matter of the agreement, you're going to go federal, you're going to stay local, or as in commercial law, you're going to have this concurrent or simultaneous possible choice of forum, right? Now, following and going to this last part in which Mexican courts are going to be resolving with a substantive foreign law, it is important to say that these 5 rules that I'm going to try to explain to you are also established in the Federal Civil Code and are set there so that if the parties have this valid agreement, whether the law applicable is foreign, then it should be applied, no? So what is the first thing that the civil code says to us? It states that the foreign law should be applied as a foreign judge would apply it, okay? For these purposes, our Mexican judge will have an extent amount of powers, no, to gather all the information needed to better understand the scope of such law, all right? So when I say, hey, I want to interpret, to do the interpretation of the New York state law, no? I'm going to have to bring in, and the judge is also capable of bringing in and gathering so much information so that he personally understands how a judge would act or how a judge would give interpretation to this substantive law, right? But I'm always making this emphasis on the substantive law because the procedural part of the claim would say and refer to those contained here in Mexico, right? So the judge is only going to give interpretation of how the judge would do it in the United States. Another important rule, for example, and Evan also talked about it, what if that foreign law has a conflict of law? Well, in that case, the judge will understand the conflict of law, and if that conflict of law determines that we should direct this applicable law to a Mexico or to a third state law whatsoever, then the Mexican judge will say, hey, I'm going to apply the conflict of law as it would have been applied in the state of New York and send the files to that or put the files in that competent law, right? So they would also like to understand what would happen if there is a conflict of laws. Also, it's important to mention that, for example, if we don't have the exact same institution of procedure to be examined by the judge, then the judge can and will be able to apply analogous figures that match the one that we are trying to apply here, or the one that we're trying to apply in the foreign law. So having that in mind, no, it's important to say that as a general rule, the Mexican judges will try to go with a really harmonious or how to say this? Yes, harmonious, I think is the perfect word, procedure in order to seek to achieve the objectives that are set in that substantive law, right? We're going to dress this Mexican court as if it was the foreign law, and then this Mexican court will apply this substantive law or try to apply this substantive law as it would have done by the foreign court. If you ask me, how often do I see this in my short career, I would like to say I haven't seen it. Nonetheless, we have these provisions contained here in Mexico, and that is why it is important for all of you to know that, for example, when a Mexican party agrees to go to New York to fight, probably they're going to end up there. But if a Mexican party has this applicable law in New York, but the competent courts are here in Mexico, Mexican courts are going to be the ones that are going to do the interpretation of those substantive rights as good as they can, or as good as they are capable of doing so, and as good as all the parties bring in the information needed for the judge to understand how that substantive law is applicable, and then bring it into the Mexican procedures and try to resolve the controversy. No? With that being said, I bet that when I start speaking, I recommended all of you that it will be better to have a tailor-made clause of forum and choice of law clause, so that we don't have to bring in any of these problems into our daily cases, right? So our final recommendation, and Evan, please open your microphone if you would like to give these final thoughts to everyone, is make sure that the clause that you're picking has the US and the Mexican parts all in together, so that you won't have to fight in the US whether it's the applicable law, the Mexican or the US law, and then try to bring the controversy to the court that is going to better resolve your problem, right?
De acuerdo.
De acuerdo.
I agree. It helps to contemplate those issues all up front. Make sure you have an integrated set of contract provisions that anticipate those different choice of law, choice of forum issues between the various jurisdictions that might apply. And then, as you just said, Juan Luis, whenever a dispute might arise, make sure if you're the one filing that lawsuit, you pick the correct forum to make sure your choice of law, choice of forum provisions will be enforced.
Thank you very much. Well, we still have 10 minutes. If anyone would like to ask us something, we are more than happy to answer. Well, that's...
No hay preguntas?
Bueno.
Okay.
Well, thank you very much, Evan. We'll talk in the future. Thank you very much, everyone, for attending. And I think we can say goodbye. Thank you.
Okay, thank you, Juan Luis. And for anyone else, if you think of questions later, I'm sure you can find our email addresses on our websites. And I'd be happy to answer any questions that you might think of after this.
Yeah,
okay.
me too. Thank
Mucho
you.
gusto. Hasta luego.
Bye-bye.